This is part 10, and from last part onwards, 9 onwards, we have started discussing the provisions of the intra-territorial and extra-territorial operation of the Indian Penal Code. In order to understand this, as I told you earlier, you have to start right from section 1 and go up to section 5 of the Indian Penal Code. And then we started with an illustration to understand this chapter very clearly. If a person who's German national is arrested at Mumbai on the accusation of the offence of murder that he has committed at London, whether the court sitting at Mumbai has got jurisdiction. In other words, whether Indian Penal Code is applicable to him and whether he shall be governed by the provisions of the Indian Penal Code. And then as we started learning various aspects as far as this first part, namely intra-territorial operation of the Indian Penal Code is concerned, when we dealt with section 2, section 1 is common section now known to everybody, that this code extends to the whole of the India except the state of Jammu and Kashmir because of article 370 of the Constitution of India with which you are dealt. Now this is a time where you refer to section 2 which says every person is liable. So now every person is liable when the offence takes place within the territory of India. Now as this offence had not taken place within the territory of India, this German national shall not be governed by what is known as intra-territorial operation of the Indian Penal Code. So this is one part of the answer, whether he can be tried as far as section 2 or whether he can be tried as far as intra-territorial operation of the Indian Penal Code is concerned, and the answer is in the negative. Now to this every person, during course of our lecture we dealt with the exceptions, and there we learned there is no exception as per the provisions of the Indian Penal Code, but the exceptions are as per the constitutional law, where I had drawn your attention to article 361 subclause 2, where president and governor, as long as president or governor is in the office of the president or the governor during the term of his office, no criminal prosecution whatsoever shall be launched or instituted or continued, whatever it might be. So no criminal prosecution as long as he is president, no criminal prosecution as far as governor, exception that is made. Then we also started discussing, taking into consideration principles of public international law, and then foreign sovereign, ambassador, foreign army, warships and alien enemy, they are also exempted as far as the provisions of the Indian Penal Code is concerned because of public international law, which is based on reciprocity, comity and equality of the nations. Now when I refer to the provisions as far as foreign army or warships are concerned, I mean this must be very clear to you that as long as the foreign army or the warships are within your country with the permission of the central government. So foreign army is stationed, warships are within your country with the permission of your central government. In that case, for example, that territory where they have station will be taken for granted as far as administration is concerned as to the territory of the particular country to which the foreign army or the warships belong, and hence the question of application of the Indian Penal Code doesn't arise. With this now, as we proceed further, whether Indian Penal Code is made applicable when the offence takes place beyond the territorial limits of India, and the answer is yes, for which you have to refer to two sections, namely section 3 and section 4 of the Indian Penal Code. Out of this, when you read section 3, whenever you want to think of applicability of the Indian Penal Code beyond the territorial limits of India, the first aspect is that the act which is done on the part of an individual to whom you want to make Indian Penal Code applicable must amount to an offence as per the provisions of the Indian Penal Code. That is one aspect. And secondly, now to whom it is made applicable. And section 4 very clearly lays down extension of the code to extraterritorial offences, namely the offences which have taken place beyond the territorial limits of India. And then If you read section 4, it says the provisions of this code apply also to any offence committed by small a any citizen of India in any place without and beyond India. 2. Any person on any ship or aircraft registered in India wherever it may be. And thirdly, it says any person in any place without and beyond India committing offence targeting a computer resource located in India. So this is where the Indian Penal Code is applicable even though the offence has taken place beyond the territorial limits of India. Out of which the first category says if it is committed by a person who is citizen of India. So at the time when the offence was committed, he was citizen of India. Now, this is not the time for you to know. Only if you come to the conclusion that he was citizen of India, wherever he may commit an offence, Indian Penal Code is applicable to him. But then, mind well, in order to know details regarding citizenship, if you read right from Article 5 or up to Article 11 of the Constitution of India, you come to know some of the guidelines which are laid down as far as who can be a citizen and who cannot be a citizen. That is one aspect. And then when you refer to the provisions of the Citizenship Act of 1955, you come to know all the details because that is an enactment meant for that. When a person, how he can acquire, how his citizenship can be terminated, all details are worked out. Now this is not the time for us to work out all those details, but we say if the offence was committed by a person who was citizen of India wherever he may be, he can be governed by the provisions of the Indian Penal Code. Indian Penal Code is applicable to such a person as far as section 4 of the Indian Penal Code is concerned. Now it says any person on any ship or aircraft registered in India wherever it may be. Now when the offence has taken place on ship or aircraft, and now that whoever may be the person who commits an offence, but if that ship or aircraft was registered in India, if it is registered in India at the time of commission of an offence on it, then wherever it may be, that will be taken as a territory of India, and then the Indian Penal Code is made applicable whoever may be the person who commits an offence on that. So here it is only when the offence takes place on any ship or aircraft which is registered in India, Indian Penal Code is made applicable. Now if you read the third category, when the Indian Penal Code is made applicable, it says any person in any place without and beyond India committing offence targeting a computer research located in India. And if you read the explanation to the section, it says in this section the word offence includes every act committed outside India which if committed in India would be punishable under this code, and the expression computer resource shall have the meaning assigned to it in clause small k of subsection 1 of section 2 of the Information Technology Act of 2000. And hence time to note you that this was an amendment which came into effect from 27th of October 2009. So this is an amendment to the Indian Penal Code because of the passing of the Information Technology Act in the year 2000. So now if this is an offence that has taken place, then as per the provisions of this section 4 Indian Penal Code is made applicable. So this is application of the Indian Penal Code beyond the territorial limits of India, which is what is known as extraterritorial operation of the Indian Penal Code. We go back to the illustration of German national was arrested at Mumbai on the accusation of commission of offence of murder at London. Whether he can now be dealt as far as one answer with which you have come, answer is in the negative, that he cannot be dealt as far as intra-territorial operation of the Indian Penal Code is concerned, for the simple reason. What is the reason? That the offence had not taken place within the territory of India, Because of section 2, which is every person who commits an offence within the territory of India is liable as per the provisions of the Indian Penal Code. The offence had taken place at London. It was not committed, and as we have taken it for granted that at London it was not committed on a ship or aircraft which was registered in India. So the question of application of extraterritorial operation of the Indian Penal Code doesn't arise. With this now, as if it was German national,
so he was not citizen of India. To any person on any ship or aircraft registered in India, wherever it may be. Lastly, it doesn't fall under three category. Any person in any place without and beyond in India committing offence targeting a computer resource located in India. In other words, what is the conclusion to which we arrive? He is neither governed by intra nor extraterritorial operation of the Indian Penal Code. But this is a time for me to draw your attention that if the person is within the territory of India, then the offence, if he has committed offence within the territory of India, then naturally, which is the court that has got jurisdiction is the next question. And in order to understand which is the court that has got jurisdiction, what we do, it is nowhere mentioned as far as Indian Penal Code is concerned. It merely says Indian Penal Code is applicable, but which is the court that has got jurisdiction? And hence, during course of time, as implementation of part of Indian Penal Code is done by the provisions of the Criminal Procedure Code, if you deal with the provisions of the Criminal Procedure Code right from section 177 up to 189, you try to understand jurisdiction of the Criminal Code. And in case of criminal law, it merely deals with, as far as Criminal Procedure Code is concerned, it deals with only one type of jurisdiction, what is known as local or territorial jurisdiction. And what section 177 says? Every offence shall ordinarily be inquired into and tried by the court within whose local jurisdiction it was committed is the principle, to which now the ambit of jurisdiction has been enlarged if the case falls under any one of the sections right from section 178 up to section 184 and then section 188 as far as the Criminal Procedure Code is concerned. So this is a time when the offence has taken place within the territory of India, that court has got jurisdiction as per this chapter of the Indian Penal Code. But what happens if a citizen of India commits murder at London and he is arrested at Mumbai? Whether the court sitting at Mumbai has got jurisdiction is the question. And to answer whether the court sitting at Mumbai has got jurisdiction or not, because there we say yes, he will be governed by the provisions of the Indian Penal Code, because this is application of the Indian Penal Code beyond the territorial limits of India as far as section 4 of the Indian Penal Code is concerned, which deals with extraterritorial operation of the Indian Penal Code. Yes, true, very correct. And now, as far as the court which has got jurisdiction, what you have to do? You have to refer to section 188 as far as Criminal Procedure Code is concerned, which deals with offences committed outside India. And what the section says? It says when an offence is committed outside India, 1. By a citizen of India, whether on high seas or elsewhere, or by a person not being such citizen on any ship or aircraft registered in India, he may be dealt with in respect of such offence as if it had been committed at any place within India at which he may be found. So, at which he may be found is the answer, which is the court that has got jurisdiction. But then the section is subject to proviso, which says provided that notwithstanding anything in any of the preceding sections of this chapter, no such offence shall be inquired into and tried in India except with the previous sanction of the central government. So in order to try him at Mumbai, previous sanction of the central government is must for the purpose of trial, otherwise Indian Penal Code is applicable. The court sitting at Mumbai has got jurisdiction because of what? When you read section 4 to be read with section 188 of the Criminal Procedure Code as far as jurisdiction of the Criminal Code is concerned. Now, as a student learning this, simultaneously a time may come when you will have to find out jurisdiction as far as civil court is concerned. And then when we talk about jurisdiction of a civil court is concerned, mind well,
This is not only one type, there is not only one type of jurisdiction. There is one type of jurisdiction what is known as pecuniary jurisdiction. The you have filed a suit for, and the amount for which the suit has been filed will determine which is the court that has got jurisdiction. If it is with respect to immovable property where the property is situated, that court has got jurisdiction. At times the court, may be having what is known as exclusive jurisdiction or special jurisdiction, though the cases, the suits relating to particular type will be dealt by a particular court. So this, if it is possible, simultaneously as with the provisions of the criminal law, if you go and deal with the provisions of the civil procedure code, you will come to know which is the court that has got jurisdiction as far as civil law is concerned. Nothing to do, don't get confused, nothing to do as far as intra and extra-territorial operation of the Indian Penal Code is concerned. But as I have told you, you start simultaneously learning the provisions which will serve the purpose from the point of view of understanding the law in general. With this now, come back to the illustration. And what is the illustration? The illustration now, a German national is arrested in Mumbai on the accusation of offense of murder that has taken place at London. Now what to do in such a situation? What is the basic principle of the criminal law? No offense should go unpunished is the basic principle of the criminal law. But can he be tried at Mumbai? No, because he is neither governed by intra nor extra-territorial operation of the Indian Penal Code. In such a situation, what is required to be done? And to find out the answer, this is the time for you to refer to the provisions of the Extradition Act of 1961. And then what is this now? If the person cannot be tried at Mumbai, he can be sent to the place where he has done an act which amounts to an offense. So that is the court which he may be sent to London where the offense of murder has taken place. And there is also a provision whereby he can be sent to the country to which he belongs also, depending upon what? Depending upon he is required to be extradited to the country, and this extradition being a treaty, and by treaty we mean agreement, this entirely depends upon the nature of the relation between two countries. But then he will be sent to the country where he can be tried. He cannot be tried by the provisions as far as the Indian Penal Code is concerned, and this is exactly known as extradition of the person when the offense has taken place. When he cannot be tried within the territory, he can be. And this is also the basis for this extradition treaty is public international law. If you find out somebody who cannot be tried by the law of your country, you hand him over to the law to that country where he can be tried by the laws of those country, and same is required to be done by that country. Where they find out somebody who cannot be tried by the law of that country but the law of India, he should be handed over to the government of India for the purpose of trial, because everybody has accepted one principle: no offense should go unpunished, is the basic principle of the criminal law. With this now, the last part, whenever you deal with this particular, whenever we deal with intra and extra-territorial operation of the Indian Penal Code, what happens when the offense is committed on a high seas? And there, in case of when the offense is committed on a high seas, if it is committed on a ship, then we are governed by what is known as floating island theory. And what is this? Ship belongs to that particular country of which ship is flying the flag, and then naturally that country will have jurisdiction when the offense has taken place, because this will be extended territory of the ship, extended territory of the nation. And hence wherever it may be, when the offense is committed on high seas, as the question of application of intra-territorial operation doesn't arise, there it will be governed by the law of that particular country of which ship is flying the flag, is the answer to this. When the offense is that of a piracy, This is an offence which is committed against the society at large, and any one of the country can have jurisdiction for the purpose of trial, as far as as far as the provisions of the law are concerned, is the aspect that you have to take into consideration. With this now, we have done with the provisions as far as intra-territorial and extra-territorial operation of the Indian Penal Code is concerned. With this now, when you start discussing right from section 6 up to section 52A of the Indian Penal Code, you come to understand as what is the heading of the chapter. I hope you have not forgotten. I had drawn your attention that heading of this chapter is general explanations, and we won't be dealing with this chapter by telling you that we shall be dealing with this chapter, for the simple reason, in order to understand this, whenever you come across a particular term, when you are dealing with a particular section, and if that term is not explained, that term is not defined, that term is not made mention as far as that section is concerned, we will have reference back to this particular chapter during course of time. With this now, when we will start right from section 53 up to section 75 of the Indian Penal Code, we shall be dealing with two aspects, namely this is on punishment. And for the purpose of understanding on punishment, what we will do, if A commits the offence of murder, or if A commits any other offence and is convicted by the court of law, what is the purpose that is served by convicting a person who has done an act which amounts to an offence? And what we are going to do during the next lecture, we shall be dealing with different theories of punishment. So we will try to take into consideration what are the different kinds of what are the different theories of punishment, and as soon as we deal with theories of punishment, we shall be also dealing with various kinds of punishment. What is the minimum sentence? What is the maximum sentence? What is the nature of the sentence that can be inflicted by the court of law, with which we shall be also dealing when we start right from section 53 up to section 75. Now this is also the time for me to remind you that during course of time I had already made mention that this is, the what is the punishment is for the judge to decide. Yes, very correct, no doubt about it. But then implementation part of it is done by the government, and then when you talk about execution, then along with this simultaneously, it may not be, otherwise, this will go on extending to any extent, as a result of which I may not be possible for me. But you, when you can spare time, if you read right from section 413 up to section 435 of the Criminal Procedure Code, because execution of the sentence is always by the government, and hence when you talk about execution, suspension, remission and commutation, you refer to the chapter that I have told you, so your understanding regarding this chapter becomes very clear. From the point of view of understanding Indian Penal Code, these two aspects when we shall be dealing with, that serves the purpose from the point of view of understanding the same. But then this is the point that is required to be again mentioned by me, that when you spare time, you go through it, your understanding as you go on learning, because once you read, it may not be possible for you to understand. So as you go on reading, it will be possible for you to understand. With this now, during the next lecture, we shall be dealing right from section 53 up to section 75 of the Indian Penal Code.